Hello, this is Steve Carlson again, and I want to go through some of these cases that Al Franken is using. Al Franken is using the same game plan that the Democrats used when they stole a lot of votes and a lot of elections down in Texas against Ron Paul. As you all know, Ron Paul is an independent type of guy. Gets involved with the Tea Party, kind of a libertarian, ran for president. And I hope you'll excuse my birds here in the background. They're listening to a recording of birds. They're very educated birds here. But this case against Ron Paul is the same roadmap which now David Lillyhouse, who now sits on the Minnesota Supreme Court, he was Al Franken's election attorney in using the contest provision that Minnesota provides to take 312 votes away from Norm Coleman and get in the Senate. And there he sits. And now he's subject to a contest under the same provision. It's called 209-12. So I want to look at just this one case. It's from 1977. It's a case involving Ron Paul. And I don't know actually if Ron Paul won or lost the election in that. I'm sorry, you can look that up. But he did lose this contest in the Texas courts from District 22, and he lost it because as soon as Gamage, his opponent, got sworn in unconditionally by the U.S. House of Representatives, I'm sure that was Democrat-controlled, he turned around and he shut down a discovery proceeding which was supposed to allow him to be deposed. And the courts were going along with this, and then he got his Democratic friends in the Congress to seat him unconditionally. Now there's evidence, as I'm going to mention here, that he stole a whole lot of votes. I mean, hundreds, thousands of votes. That the evidence was there. They wanted to make sure that, this election against Ron Paul was not stolen. I have a strong sense that it probably was. I'd like to see a lot more evidence. Now, so this was brought because the judge was going ahead and proceeding in an election contest under Texas's contest laws. And he did actually get one recount, but he wanted to show additional evidence about all these stolen votes, such as more people voting in a county than were registered, or people. I'll go through the exact thing towards the end. But so he wanted to have discovery, and this judge, Judge Compton, it's called Gamage versus Compton, had arranged for this, but he scheduled it until after this hearing could be held at the Texas Supreme Court to see if they should proceed. And essentially what they did was they shut down all discovery on his very suggestive case of voter fraud. And so what he wanted to do in this mandamus proceeding, which is the court comes in and supervises and directs the district court to stop, he wanted him to cease and desist from pursuit of the election contest under the state of Texas's court procedures. So they actually go to a Minnesota case, and I'm from Minnesota, and it's called Odegaard versus Olson, one that Al Franken has not brought up directly, but is very interesting because in that case, when I talked in video 2, that this is not just a political question committed to the U.S. Senate. And that is because it's very clear that there's another section called Section 4 of Article 1, and all that Al Franken talks about is Section 5. But there is another Section 4 which gives a grant of authority to the state of Minnesota to come up with free and fair election laws. And in that case, in Odegaard versus Olson, this was in 1963, and the election law was different. We didn't have 209-12, which allows us to gather and certify evidence to bring to the United States Senate. And so they contested I don't know if it was Odegaard or Olson, just a long time ago, but he was running for U.S. House of Representatives, doesn't say which district, and he sought to enjoin the Secretary of State at that time. Now the Secretary of State has been Mark Ritchie, has changed to Steve Simon, and tried to enjoin him from issuing a certificate. And now the facts of this case are now that Mark Dayton has violated the Minnesota election law. I want to show you something. This is an article. This is exhibit number 1 from the U.S. Senate to Mark Ritchie. It's October 1st, 2014. And what it says is that federal law, when the result of an election for U.S. Senator has been officially ascertained, and that would include the contest which was pending, and so they're actually violating federal and Senate procedures in sending this unlawful election certificate, because this is from the Secretary of the Senate. Her name is Nancy Erickson, the United States Senate. It says, when the result of an election for a United States Senator has been officially ascertained, federal law 2 United States Code 1 A to B requires that a certificate of election must be signed by the governor, in this case Governor Dayton, attested to by the Secretary of State, Mark Ritchie, the defendant in this case, have a seal of the state affixed, and must be provided to the President of the Senate. I don't know if that needs to go directly or if it can go through the Secretary. And so what this says is that you can see that even the Senate reorganization includes Minnesota law, because it has to, this signature by the governor and by Ritchie, it shows that our provisions are being followed, and I've already mentioned those in the previous video, which is 209.12, the congressional election election contest provision, and which is different than Texas's law because it puts right in there a kind of fraud and corrupt practices language that says you can include material, serious, deliberate violation of Minnesota election law, as Al Franken and his party have systematically engaged in throughout not only 2014 but 2012. And those are just the elections in which I've looked into it because I was involved as the Independence Party nominee in this state, Minnesota. And where do these come from? And so Odegaard said this in actually denied the right to stop the issuing of an election certificate. And the court said, this is the Minnesota Supreme Court, while the state legislature may regulate the conduct of elections subject to limitations expressed in United States Constitution, Article 1, Section 4, it should be conceded that under the provisions of Article 1, Section 5, each House of the Congress is the sole judge of the election, returns, and qualifications of its members, exclusive of every other tribunal, including the courts. Now, I certainly disagree with that. As I said yesterday, first of all, they misread what Article 1, Section 4 says, as the Texas court clarified it. But it's not the fact that Article 1, Section 4 is there to put limitations on the state legislature's conduct of the elections here. That section of the United States Constitution requires that the legislature prescribe the election and safeguards for it. I'm going to go through that a little bit more in the words of Justice Hughes in a case relied on by the Texas court. This is the United States Supreme Court from around the turn of the last century, I guess. And as I've said, what Article 1, Section 4 actually requires is that the state of Minnesota regulate this election and the safeguards. So the question in this case, in Carlson versus Franken and Ritchie, is is the prescription of the state legislature being followed? And does it have to be followed? And I say yes, it does have to be followed. And the charge is that the courts and Secretary of State Ritchie and Simon and Governor Dayton and Lori Swanson are simply ignoring that prescription that's established in advance, written before. And I contend that that prescription is mandated by Section 4. Note that this grant of power to the legislatures modifies the absolute grant to the Senate, on which Franken is misguidedly relying. So, Respondent Paul then looked at Rodebush, which was another United States Supreme Court case, and this one specifically addresses Article 1, Section 4. And that was a case, I guess it was around 2004 or something, and the Supreme Court held that, quote, a recount is an integral part of the Indiana, this was from Indiana, electoral process, and is within the ambit of the broad powers delegated to the states by Article 1, Section 4, unquote. And so the Supreme Court has recently held that the contest provision on which Al Franken relied, and which also includes fraud and corrupt practices, which are alleged here, those contest procedures established by the states are within the ambit of the broad powers. It refers to broad powers which the United States Constitution does delegate to the states. And so a judge on that panel from Texas said there's no reason the state of Texas may not protect and enforce its election laws by permitting election contest actions in court, just so long as these actions do not impede an independent determination of the election result by the United States Congress. And it said that the Senate could make its own determination, and the panel here kind of said, well, maybe the Senate will make its own determination, but there was no evidence that that was going to happen, and they should have gone ahead and allowed the discovery, including the deposition of Al Franken and Mark Ritchie, and I posted some interrogatories which I served on them on the internet. Now, here's the kind of fraud that Paul was talking about. Ron Paul. He claimed knowledge of at least 500 persons who illegally voted for Gamage in the November 2nd, 1976 election, and they only were 270 votes apart, and 300 of those ballots were from one county, Fort Bend County, and 300 more people who supposedly voted but cannot now be found, and of a number of voters who allegedly were either residents of other states or not physically present within the state on Election Day. And in 20 Harris County precincts, which Gamage carried by a substantial margin, 149 more votes were counted than there were persons voting. So that sounds kind of fishy. He also complained of irregularity in the counting of absentee ballots, asserting the election judge involved was a paid employee of Gamage, and so there's definitely a there, I think. And now, the way that the Texas court judge here, in this opinion, states this, that they were called upon to determine whether the proceeding contemplated by Judge Compton, and they were reviewing whether he could do this, as a presiding judge of the 151st Judicial District Court, is a forbidden infringement on the power of the House of Representatives, as Al Franken now claims, under Article 1, Section 5, or the valid exercise of the state's power under Article 1, Section 4, to describe, and actually the word is prescribe, the times, places, and manner of holding elections. And so you can see that this Judge Compton saw his judicial role as part of that prescription by the Texas legislature. And the court itself saw this as requiring a balancing between Section 4 and Section 5 of the Article 1 of the Constitution. That covers the Congress. And so they say, well, to be sure, the power of the House of Representatives to seat a candidate is non-justiciable. It's a non-justiciable political question. It's a question that would not have been the business of any court. However, the question here was not who is to be seated, and this is the same case in Franken, by the Congress of the United States. Rather, he is requested to decide those certain questions and issues which have come to typify and characterize an election contest. Namely, in his case, how many votes were lawfully cast in a state supervised and sanctioned. So there's the corrupt practices election. It has to be a valid election. And how many votes were illegally cast, how many votes were lawfully counted by and for whom, and similarly, how many votes were illegally counted, if any. And in Minnesota, we've added the issue of are there any questions of Franken's right to office because of serious material and deliberate violation of Minnesota election law provisions. Now, even though this is not a recount contest, this is a fraud and corrupt practices contest, the court noted that such an inquiry would be required ultimately to address substantive questions and issues regarding the registration of those within the district who purported to vote, the integrity and accuracy of the vote inspectors and canvassers, and the procedural discharge of their duties in both the counting and recounting of votes, and in the making and publication of a proper return. While the answers to these questions may be of interest to the Congress in its ultimate determination of who shall be seated, Congress is not bound by the answer to any of them. But these inquiries are clearly of direct concern and interest to the state. Here, the voters of the state of Minnesota, in the administration and enforcement of the election laws pursuant to which the voters of, in this case, the state of Minnesota, were to select in a democratic fashion their own senator. Here's where we get to the U.S. Supreme Court. This is a case from 1932, actually. Chief Justice Hughes, writing in Smiley versus Home, both recognized and defined the breadth of the permissible state powers under Article 1, Section 4, which is at stake here. And he wrote, "It cannot be doubted that these comprehensive words in Article 1, Section 4 embrace authority to provide a complete code for congressional elections, not only as to times and places, but in relation to notices, registration, supervision of voting, protection of voters, prevention of fraud and corrupt practices cited specifically by the Supreme Court, counting of votes, duties of inspectors and canvassers, and making and publication of election returns. In short, to enact the numerous requirements as to procedure and safeguards." That means action by the Minnesota courts. We're talking about the Minnesota Supreme Court and the Ramsey County Court, and this panel appointed in Ramsey County by the Minnesota Supreme Court in 2014 was denied in 2012. And it says that this is to be followed. This is the United States Supreme Court, and they have just violated that. And these experience shows, said the United States Supreme Court, are necessary in order to enforce the fundamental right involved, and that is the right to vote, which is enshrined in this very Article 1, Section 4. Now, the Texas court says this writing of Justice Hughes enumerates those functions which are the subject of the election contest proceeding now pending. And this is what was pending when Mark Dayton illegally issued that election certificate to Al Franken, his friend. And Texas has found, it said, along with many other states, that among the procedures necessary to guard against irregularity and error in the determination of election results is the availability of both a recount and, if necessary, an election contest. Despite the fact that a certification of election may be issued to the leading candidate within 17 days after the election, the results are not final if a candidate's option to initiate a contest is exercised. And this is the law also in Minnesota. And it was exercised, and they went ahead and gave a certificate of election, which according to Texas law and Minnesota law is not official. It's not final. But Al brought that up, and now he wants to turn around and say that there's no power. There's no power in the state of Minnesota to have this election contest. Well, of course there is. Now, the court goes on, it is true that a state's verification of the accuracy of election results pursuant to its Article 1, Section 4 powers is not totally severable from the power of the House of Representatives, in this case the Senate, to judge elections and returns. But a recount or an election contest can be said to usurp the function of the House of Representatives only if it frustrates the ability of the House to make an independent judgment. And this is absolutely what I've been saying to the panel headed by Judge Van den North, and that they and the Supreme Court have usurped this power of the ability of the House to make an independent final judgment. And in fact, when the Minnesota Supreme Court demanded $500 to stop this partial judgment, and in that case, from being reviewed, and in fact, they had already, because this was on January 5th that they did this. Well, December 19th, this letter from Governor Dayton and this election certificate, which Franken grabbed, had already run up or brought it up Senate to Washington, D.C. So, but they still were asking $500. And what this did was it frustrated the ability of the Senate to get the information that Minnesota law provides be provided to them. Now, if you deny them that evidence, then they cannot make that independent final judgment in the U.S. Senate. They're acting in the absence of real evidence, and in fact based on a fraudulent, a corrupt, and false, unlawful election certificate by Al Franken. And because now an election contest does not prevent the senators from independently evaluating the election any more than does the initially announced election result. And that's not illegal, is it? And the court found little reason for distinguishing between an exhaustive election contest, like Al Franken won by to get in 2008, concerned with the substantive procedures of the election, and to distinguish that from a mere cursory recount. Their objectives are identical. That is to say, to determine and designate the most popular candidate. And as Justice Hughes said, the comprehensive words of Section 4 undoubtedly extend to the prevention of corrupt practices and certainly unconstitutional practices and of safeguards. This is my complaint. The politically elected judges at the Supreme Court of Minnesota, which now include Al Franken's elections attorney in 2008, David Lillyhout, and they evidently embraced the constitutionality of the wide-ranging 209-12 contest provision, are now refusing to provide the safeguards for the Independence Party and me and the independent voters, which I am, through the manner of safeguarding and enforcing the substantive rights granted by Minnesota election laws, prescribed by. Now, because all these grounds are of serious, material, and deliberate violation of Minnesota election laws. The court went on to say an election contest is an integral part of the Texas electoral process and is within the ambit of the broad powers delegated to the state by Article 1, Section 4, which I am relying on, of the United States Constitution. All these voters and officers and the legislature and the candidates, the parties, the Independence Party, are in confident reliance upon an implied assurance from the state of Texas, in this case Minnesota, that the election to which they sought to dedicate themselves would be conducted in an honest, fair, and otherwise impartial manner, and in accordance with the law, as codified in part by the Texas Election Code. So the law is not just what's in the code, it also includes the Constitution, for instance. There is now a concomitant duty on the part of the state to determine the integrity of that election process and thereby reassure all citizens, including respondent Ron Paul and his supporters, that their confidence is well placed. And if you believe that, there's a bridge in Brooklyn. Oh, that's where Al Franken is from, isn't it? And in this regard, an election contest is an end in and of itself, which is accomplished when the results of the election and the right to certificate of election are declared by the court, in this case, the panel. Congress cannot decide how this state declares an election or to whom the Texas certificate is delivered. And this is what the Brooklyn Bridge guy, Al Franken, has done. He's kind of hustled the panel and the governor to get this piece of paper. But it's, and he said, well, look at right here. It says this has to be well before the term, which begins on January 3rd, it says. Well, it didn't begin on January 3rd. It began January 6th. But they said, well, of course, that cuts out anything after January 1st, New Year's. Of course, you got Christmas in there. And let's just say this was a Christmas present to Al Franken from the courts, another one, which is to let him use this false election certificate to fake out to put on the United States Senate, as if we had complied, he had complied with the very Secretary of State's, the Secretary of the United States Senate request. And it said they wanted to make sure that they got this to them in time. And so they didn't even ask Al to break the election rules. They thought that he and Governor Dayton, Mark Ritchie, would be following that. Now, instead of Congress telling us how to do it, these decisions are accomplished, not recommended or advised, by the Minnesota election contest proceeding, including the time for issuance of the election certificate, which cannot be until after the contest has been finally determined by a court of competent jurisdiction, which it was not. Now, in order for preemption to occur by such things as 2 USC, which I don't think it has occurred, there has to be an actual conflict between the federal and state statutory schemes such that both cannot stand in the same area. And that's from the U.S. Supreme Court case 1963, Forder, Lime, and Avocado Growers. Doesn't that sound good? But as a matter of fact, here, there's no conflict. Our Minnesota law was much more sophisticated than Texas's, and simply, it doesn't advise, but it does provide evidence so that an independent decision should have been able to be made by the U.S. Senate, which could not, because it only got one little piece of information and so-called evidence, and it was false, because it wasn't really a valid certificate. So, just about done with my analysis of this case, Gamage versus Compton. Gamage versus Compton. And it's from 1977. It's the Ron Paul case. And this panel needs to stop Al Franken from doing to the Minnesota Independence Party and to my contest, my race against Al Franken, the same kind of cheating and playing with the election rules. Now, when I first started this, back in September. You can look on my YouTube, and you can see when I first recorded a phone call of them informing me officially that they had decided, Al and Mike McFadden got involved and said, we're only going to invite the Republicans and the Democrats. And they didn't say not Carlson. They said not the Independence Party. And that is because virtually all of the seats in Congress were held by Democrats or Republicans. And on that basis alone, they excluded a whole party. Now that upsets many people, and it doesn't have anything to do with me. It has to do with a duopoly that is abusive of our elections and disrespectful of the rights of the people of Minnesota to have free and fair elections. And so this is, again, going to be part of my argument to that panel tomorrow, a 3-judge panel, one from Hennepin, Ramsey, and Anoka counties, the 3 big voting counties in Minnesota, right around the Twin Cities here. And I hope you'll follow this, because really what's at stake here is not only the rights of independent voters, but the very essence of democratically elected representatives to Congress, on which our Constitution, our country is constituted and established. I'm Steve Carlson, and I approve this message.
To complicate matters, female cardinals also occasionally sing. In this